today. And for the cases, they're all the same sort of issue. It's an older adult with various degrees of memory impairment. And the issue is that they need some sort of life-threatening surgery, something serious. So for example, amputation for a foot ulcer with somebody with terrible circulation, or placement of a pacemaker, or some surgical procedure for life extension, something serious. And the question is, who decides? Who makes these decisions? So next. So there's round one. Let the boxing begin. Okay, let's go. So this is Betty. She has mild dementia and resides in assisted living, and she declines the surgery. She says, I've lived a good life, but her family is pressuring her to have the procedure. Who decides? So next slide.
So ladies and gentlemen, fundamentally, I think that the message here, which we're going to repeat over and over and over, is plan in advance, okay? None of us know when we're going to be hospitalized. None of us know when we're going to be facing a life-threatening illness. In the world that we currently live in with COVID-19, those decisions need to be made now, while you're competent, while you're able to make them, and because we've had reports of many cases in which folks are asymptomatic and then suddenly critically ill. And there's no time to make decisions as to who to name as your decision maker. So that's the crux of the thesis today. Plan in advance.
Right. So next slide. So first of all, we need to get our terminology right. And a lot of us say, well, is the patient competent to make that decision? Well, competency is a legal word, and somebody can only be declared incompetent by a judge in court, right, Kerry?
That's correct.
So,
that's correct.
Yep.
In the context of a guardianship case, and what I call a lifetime probate.
Right. So we use that word like, oh, he's so incompetent, but it's really a legal term, and I try to avoid it. The better word that doesn't roll off my tongue as easily is capacity. And that is basically a functional assessment and a clinical determination about a decision that can be made by a clinician of the patient's case. And so, even, for example, does a teenager have capacity to manage their money? Probably not, but they can do other things. And so when I think of capacity, I think, can this patient make this decision at this time? Maybe I don't want them doing my taxes, but some folks still have varying degrees of capacity in their older years. Next. And this is an old article by Drs. Applebaum and Grisso, but it's a classic, and it's, if you ever want to read a little bit more about how to assess capacity, this is the standard. And basically, 4 components that I look at: is the patient able to communicate a choice? So if somebody's, English as a second language, get an interpreter. If somebody's hard of hearing, write. There's different ways to communicate with our patients, and it's not always just talking. Does the patient understand their options? Do they understand what happens if they do the surgery or they don't do the surgery? Do they appreciate the issues, the risks, the benefits, and then can they reason it through? Kerry, is there anything else that you would talk to a patient about if they were trying to, for example, make a big legal decision?
Well, I think that lawyers kind of do it slightly differently. And at the end of the day, are we talking about a legal decision or a medical decision? Lawyers frequently kind of what I call back into the analysis, which is, does the client have the capacity to sign a power of attorney for healthcare? Does the individual have the capacity to sign a deed? Do they know they're signing a contract to sell their house? So in the eyes of the law, we have 2 types of capacity. One is testamentary capacity, which is, do I have the mental faculties to do an estate plan? And the second is contractual capacity. And I think in the eyes of the law, those 2 have been pushed together rather succinctly of late. But lawyers assess capacity based on what is the act we're asking a client to have the competency to perform.
Great. Next slide. And again. Kerry, this is your slide. Why don't you talk us through this?
So let's talk about powers of attorney. Powers of attorney are a critical document. Again, we're living in the world of pandemic COVID-19. Every single person listening and every single person you know over the age of 18 should have powers of attorney. In Illinois, we have two kinds. One kind is called a power of attorney for healthcare, the other a power of attorney for property. The concept is, while I am mentally competent, I name someone else. So in our example, I name Dr. Braund to be my agent. I am the principal, not of the school. I am the principal, and the agent is Dr. Braund. She is entitled to make decisions for me for my health care, which is what type of treatment I get. Am I going to donate organs? What is my end of life decision-making preferences? Very, very important, again, in the world of COVID. Do I want to be on a ventilator? And if I name Dr. Braund as my agent, she's entitled to manage my assets, power of attorney for property. Property is a generic term. It doesn't relate exclusively to real estate. The only fly in the ointment to my example is, if Dr. Braund is my doctor, she is not entitled to be my agent under power of attorney for healthcare. So again, critical documents, get them done, ladies and gentlemen, particularly in the world we're living in today.
Next.
So powers of attorney can be abused. They're terrific advice when used appropriately. You're going to want to name someone that you love and someone that you trust, and someone that loves you a lot more than they love your money. Okay? People traditionally now don't go into banks with guns and say stick them up, because everybody gets to wear a mask now and go to the bank. What people do is they go in with a power of attorney for property, and that power of attorney is abused by taking money out of the principal, or typically a cognitively impaired older adult. So it's very important that you pick somebody that you trust. It's very important in the healthcare arena that you discuss what treatment you want and what treatment you don't want. We can be kept alive today on a variety of equipment and machinery a lot longer than perhaps some people really do want to be kept alive. But that's a family member decision if they're named agent, along with the doctor's recommendations. So again, powers of attorney, very, very important. Two kinds: healthcare, property. Next slide, Laura.
So what I would say with Betty is she able to make this decision at this time? And if I talk to her several times and she continues with this rationale that she doesn't want this surgery, knows she's at the end of her life, if she's able to communicate, appreciate, and reason, she can make her own decision. And then my job is to help the family accept her decision. And oftentimes families want much more aggressive care than the older adult would want. I have many of my 90-plus-year-olds saying, if I died tonight in my sleep, I'd be so happy. You know, I've lived a great life. And everybody's, a lot of my seniors, they fear dying in a hospital connected to machines and technology that they don't want, but sometimes the families can't let go. So very important to name somebody as your agent on your power of attorney who can make these difficult decisions. Next. Oh, keep calm and get ready for round two. Kerry, do your ding, ding, ding thing.
Ding, ding, ding. right, here we go.
All right.
Here we go.
Actually, Kerry, I have to tell you something funny. When I was in med school back home in North Dakota, every fall we had the law med football game. And the law school is like 4 times as big, and they had all these big burly athletes. And we had a bunch of dweeby science majors, and it was just a blowout. It was really actually kind of pathetic. So that's when she asked us to box. That's the first thing I thought of was, oh, I'm going to get beat up again.
Not today.
Today, yeah.
Not today.
So
you're not getting beat up.
We're virtually boxing. So same case, Shirley has moderate dementia. She really cannot understand the issue. She's not able to make the decision like Betty was, but here's the fly in the ointment. She does not have a durable power of attorney. She didn't come to our lectures, Kerry. So next slide. So this is where I call you. Next slide.
So if an individual does not have a durable power of attorney for health care, the Illinois legislature and the Illinois Probate Act has already decided who will make decisions for you. So this is important because you may not want are listed up here to be making these decisions in order of priority. And in general, it's basically closest bloodline. Of course, it starts with a guardian. That's a court-appointed third-party decision maker if the patient has one. Most patients go in a hospital and do not have one. Or if you're married, the patient's spouse. Now, fly in the ointment here. What if you're married and you have a divorce pending? Kind of an interesting scenario. And of course, today the law applies to a civil union partner or a domestic partner. If you're unmarried, it becomes slightly more complicated. But today, usually, the hospitals will recognize a long-standing domestic partner. Take a look at cue ball number 3, though. Any adult son or daughter of the patient may make the decisions. Now, this is where really it gets kind of dicey. I've been involved in a number of cases. I was involved in a case in which the issue was, should the patient have brain surgery? And there were 2 children, a son and a daughter, and they couldn't agree on whether or not the mom should have brain surgery. So the hospital filed a proceeding, a guardianship, a lifetime probate case, to determine the patient's ability to make their own decisions and ultimately to appoint a third-party decision maker who consented to the neurosurgery. And under number 3, if you have 3 children and 2 say surgery and 1 says no, the one that says no is supposedly under the law have 24 hours to go into guardianship court, to probate court, and overturn that decision. So you can see all the way down the list, and Doctor, maybe you can comment as well from a medical side. Number 7, the decision maker is a close friend of the patient. Now, I don't particularly care for this as a lawyer in any regard, because all it takes is a person to come in and say, I'm a close friend of that person who you're challenging their mental capacity to. Frequently, that individual, the patient in the hospital, is not able to communicate, and this close friend comes in, signs an affidavit, and says, pull the plug. That close friend may be a beneficiary on that individual's money. And that's a problem. Next slide, please.
Yeah.
So, in the context of a patient with diminished capacity, we've now talked about no planning whatsoever. The Healthcare Surrogate Act applies. The surrogate decision maker is to act on what we call the best interest standard. That's contrasted for, excuse me, for substituted judgment standard. But the best interest standard is, can the surrogate make a decision weighing the benefits and the burdens of the treatment, and likewise the benefit and burden of not having the treatment. Surrogate is obligated to take into account other information, the views of the family, friends, that the surrogate believes the patient would consider if they were able to act for themselves. So best interest scenario, again, I pointed out a pretty dramatic conflict with a close friend concluding the best interest is pull the plug. Next slide, please. Substituted judgment. This decision is supposed to be as close to what we believe the patient would have done under the intended circumstances. So you're supposed to stand in the shoes and substitute your judgment for that of the patient. Substituted judgment as against best interest. Very murky.
Gary, I have a question on that. I just, I'm standing at the bedside, with this dilemma, and how do I even know what this patient would have wanted? How do I know that this close friend is making a reasonable decision? I mean, it's just substituted judgment I find so challenging.
Well, I think that all of these types of scenarios are challenging, and I think that for the most part, you're supposed to rely on third parties or third-party evidence or evidence of some kind. Did this patient at some point write down what their wishes were, even if they didn't do a power of attorney? Did they tell their pastor, priest, or rabbi what they wanted to do? In these end-of-life decision-making cases, and I've litigated far too many of them because people didn't plan, it is a conflict. Talk about boxing. It's a conflict of ethics, morals, religion, and philosophy, all combined in the courtroom where it shouldn't be going on. But the question, of course, is if someone doesn't express their desires and put it in writing, how is a judge going to conclude? How's the doctor going to conclude without relying on outside parties? And the courtroom scene when we have people testify, this is what Aunt Millie told us she wanted, or the pastor comes in and says, in a Jehovah's Witness case I was involved in, a fellow fell off a building on Michigan Avenue, and he was supposedly a Jehovah's Witness. His wife says he was, and there were others who said they weren't sure. And at the end of the day, religion, morals, ethics, philosophy, including the beliefs of the judge, come into the picture in terms of a determination. Do we allow blood? Do we allow the amputation? Do we allow this individual to die peacefully? Or is the family going to continue to fight? And more often than not, ladies and gentlemen, follow the money, because that's what it's all about. Next slide, please. Doctor, you want to take that?
Yep. So somebody needs to decide, and without documents done ahead of time, it may not be the person Shirley wanted, but she missed her chance. So a decision needs to be made, and as Kerry said, this is difficult on the patient, the client, and the surrogate, never mind time-consuming and expensive. So by now, if you haven't figured out that the point of this talk is do your advanced directives, wake up. Next slide.
We have a quick question that I'd like to read here. If you are married, is there still a need for advanced directives?
I would say yes. And the two things that come to my mind, Kerry, one is the husband or the spouse may not be the person you want to make the decision. People have different opinions, whatever. The other thing, if you're 90, your spouse is probably elderly as well and may be emotionally distraught or stressed out and not being able to make a good decision. So I wouldn't assume that it would automatically be your spouse. What do you think, Kerry?
Don't forget the Terry Schiavo case. Terry Schiavo was that famous case. I gave lectures for years saying, don't be the next Terry Schiavo. You may recall Terry Schiavo was involved in a horrific accident. Her parents believed that she was going to come out of, in essence, a semi-comatose state. And her husband testified that he didn't believe she wanted to remain alive on machinery. It was very, very horrible case. It wound its way through the courts. It wound its way through the legislature. You may recall it ended up on President Bush's desk in Terry Schiavo scenario. And of course, what was behind the scenes and got some press was Terry Schiavo's husband, who was advocating that the plug again be pulled. This is that's a term I want to use intentionally. The plug should be pulled on my wife. He was already involved with another woman. So you wonder, do you want your spouse to make those decisions? Some people think that could be the right decision. Some people think not. And many spouses, believe it or not, have never discussed end-of-life decision-making. How do I want to go out? Because nobody wants to face their own mortality. So at the end of the day, the answer is, I think you should do advanced planning. Don't forget that durable power of attorney for healthcare also allows you to decide in advance, do you want to make organ donations, okay? And what type of end-of-life treatment, which we've talked about. So I think that it's much, much better and cleaner and easier for everybody involved, the hospital, the doctor, the patient, the family, to have a person's wishes written down before they reach the bottom of the ninth inning with 2 outs.
Kerry, this is boxing, not baseball.
I'm sorry.
No more sports.
Before they get the knockout punch.
Yeah, ooh. Okay, next slide. So I'm going to say it again. Please, please, please encourage your patients, clients, families, kids, parents to complete a durable power of healthcare. It's easy to do. It can be 2 pages. You can download it for free. All you need is a witness. It doesn't need a notary. It doesn't need a lawyer. Sorry, Kerry. And once you get this document done, spread it around. Make sure that your healthcare team has a copy, that it's scanned into your EMR of your local hospital. You know, don't put it in a safety deposit box. Next.
Yeah, that's a very important point. Don't put your powers of attorney in a safety deposit box. Banks close on weekends. And as a result of COVID-19, all the banks have changed their hours. You're going to need this document. God forbid you get stricken with COVID-19 or some other critical illness. You're going to need that document now, not when the bank opens.
We have another question.
Okay.
I know you don't need a lawyer to get a short power of attorney for healthcare. Do you need an attorney for a power of attorney for finances?
Well, despite the fact that you may not need a lawyer, I think you should use a lawyer. The reality is that the power of attorney for property requires notarization, requires 2 witnesses, and there are some significant ins and outs in creating a power of attorney for property. And particularly the question is, what power are you giving your agent? Are you giving your agent the power to file your tax returns? Are you giving your agent the power to invade your money? Are you giving your agent the power to give gifts? Are you giving your agent the power to do estate planning? A lot of very sophisticated questions need to be answered in conjunction with the power of attorney for property.
And another question. When a senior patient has limited capacity and wants to live alone and is clearly not safe to live alone, if the POA will not make the decision to ensure their safety, what do we do as healthcare and senior providers?
This is such a challenge because we're seeing more unbefriended elders, people that don't have family. They generally are very limited finances. Their options are very few. And as you know, any kind of congregate living or caregiving, it's expensive. It takes a lot of cash. So we're really seeing more and more of these people. And when they come into the office, they're losing weight, they look disheveled, they're not taking their medications. There's nobody for me to interact with. And at that point, I would call up my adult protective services colleagues and have them go out and do a check and see if we can get this person connected with CCP program and various other things. But I think all clinicians and people who work with seniors have to have on their radar the elder abuse and self-neglect idea. It's out there.
And following up on Dr. Braund's comments, the adult protective services people, depending on the severity of the situation, may or may not initiate via counsel a guardianship proceeding. And a guardianship proceeding, of course, is a determination as to whether that unbefriended older adult requires a third-party decision maker. And the court will determine that, in downtown at the Daly Center today, we're doing all those proceedings by Zoom. I appear in court almost every day by Zoom. And again, that guardianship process is a determination as to an individual's capacity to make their own decisions. And if they're an unbefriended elder and they are disheveled and perhaps their house is hoarded and they haven't paid their bills, or alternatively, as the doctor suggests, many people that are older are used, exploited financially. Financial exploitation goes hand in hand with cognitive impairment. As soon as the piranhas in the neighborhood or relatives decide that an older adult is cognitively impaired and has some money, the fish move in to chew up that money and chew up that person and take financial advantage of them. And that's when Adult Protective Services gets involved and potentially files with a lawyer the guardianship proceeding to seek the appointment of a third-party decision maker to assist that individual in maneuvering both daily life and avoiding further financial exploitation. Next slide, please. We
have another question.
Okay.
Many healthcare power of attorneys are being completed in our hospitals. With that said, a lot of them are not being notarized. Is the healthcare power of attorney still legal?
I don't think it needs a notarization.
Just a witness.
Just a witness.
Yeah, we do them in our office all the time. I guess my only concern, if it's sort of done under duress and in an emergent situation, is that patient being coerced? Are they making the best decision? We prefer to do it in the office and in a more thoughtful way, but sometimes it's rather obvious who the agent is going to be. We just need to put it on the paper. So it's not my favorite way to do it, but it gets it done.
I don't particularly favor the concept of doing it when a patient is sitting at the admissions desk and they're being asked to sign in and sign in. Sign here, sign here, sign here. I would endorse, if you're doing it at the hospital or doing it in the office, it's a whole different ballgame than doing it upon admission to a hospital.
Yeah, for sure.
Next slide, Laura.
We have another question.
Okay.
Who should have a copy of a completed healthcare power of attorney?
Your doctor. Your doctor
and all your agents.
Yep.
So if I've got my husband and my sister and my daughter, they all need to have a copy of my most recent one. I actually have a hanging file at home of all my family's power of attorneys for healthcare. And I'm on some of them, I'm not on others, but at least I've got them. But a lot of people don't think to do that. And it doesn't do any good if it's hidden in a safety deposit box.
Again, I agree. You should give it to your agent. You should give it to your doctor. But talk to your agent about your intentions. This is what I want. We frequently have clients that come in and say, I would never name daughter number one as my agent under power of attorney for healthcare because she will never remove me from a ventilator. She will never remove me from life-sustaining medical equipment. And so as a result, they pick a different child who they believe has, in essence, the fortitude to make that hard decision. So, and only family and family dynamics are understood by the people that are in it. So talk to your agent about what you plan to do.
We have another question. What if the patient is alert and oriented, but cannot return home safely, but refuse placement? The patient also has no one to care for them.
So this goes back to, self-neglect and all that. I will say as an aside, my pet peeve is alert and oriented. So yesterday I was admitting a lady with moderate stage Alzheimer's to the assisted living, and I was going through the nurse's notes and they were saying A&O times 3, A&O times 3. And I'm like, really? Because she has a mini mental score of about 12. But she presents well, she's friendly, she's interactive, but that does not mean that she can take care of herself or make good decisions. So sometimes hospitals will have the ability to do a neuropsych evaluation, and Dr. All is going to talk to us about that a little later this morning, about the role of that. But, A&O times 3, when you hear that, your little antennae should go up because it's probably not true. So that is a patient then who we need to pull in family or APS or whatever to make sure that it's a safe discharge.
Doctor, would you tell our listening audience that 11 or 12 out of 30 kind of give us a...
Yeah, so MMSE mini mental state exam, it's an old, not very good cognitive screen, and it's like, what's the day, the date, the year, where are we, say these 3 words in a couple minutes, what are those 3 words? And it's just a very gross evaluation of somebody's cognition. 30 is normal. High 20s is fine, but when you get to the point where people can't remember 3 words at 3 minutes, or they can't spell a word backwards, something like that, there's some cognitive issues that need further evaluation.
Thank you.
We have another question. Should a power of attorney be updated after a certain number of years?
Ooh, yes. There's a great mnemonic, the 4 Ds, and it's something like after death, divorce, disease, and decade. And I can't remember who said that, but I loved it. But, I've seen power of attorneys that are completed 15 years ago, and 3 of the 4 people that are listed in order are deceased. And so it's if people have the cognitive ability, they probably should complete a new one periodically as your life and situation changes. And interestingly, when you're 50 years old and young and healthy and you feel great and it's easy to say, I don't want anything done, I always just want to be cool like I am now. But then you go to talk to older people and they're like, yeah, I want a mammogram. I'd go through a biopsy, why wouldn't I? And so you have to really keep interacting with folks.
Life is a question of perspective, and one's perspective is constantly changing.
For sure.
Kerry and Dr. Braund, there's a couple conversations in the chat. Do you have Adult Protective Services information? How does one go about to find who the APS resources are in their community?
There is a 1-800 number, and if I'm really cool, I can pull it up for you a sec. If you call the 1-800 number, then they will, get you in touch with your local people. So this is the Adult
Lauren, do you have that
Protective
number?
Services.
I have it as well.
So 866-800-1409. And that's, I keep it in my phone, you know, like I can be at the store and see something I don't like, but if you're working in a certain area, you might get to know Catholic Charities or NorthShore Senior Center. You get to know the people in your area, but the 800 number is good to have.
We have a couple spectators put it in the chat room. So if people didn't get it, it's in the chat. You can pull it up. Great. Here's a story someone shared that they had a client who had APS at their door. The son had passed away and the home was not habitable. We hear this a lot. The police took her to a family member who they have no money and now they're calling. Shouldn't they have taken this individual to the hospital or called APS? It's like dumping from one environment to another environment and there's no resolution.
Well, and as somebody who works in the hospital and wanders through the emergency room every afternoon just for funsies, like the hospital is the place of last resort. So these people aren't sick, they're not hurt, but you know, somebody will call 911 and they end up here and we clean them up and give them a hot meal. And then it's a big discharge problem, but you know, we're fine with that. But it's really tough. And some of these people have lived that way their whole lives. I mean, in America, you have the right to make bad decisions. And so we all have that house in our neighborhood where the grass is long and the shutters are falling off. And you can only imagine what it's like on the inside. But they have the right to do that until the village or the city, you know, declares the house inhabitable. But when it becomes a senior, it's a little different story, and that's where you have to at least have Adult Protective Services evaluate them.
Thank you.
We have another question, and it's back to the mini mental state exam of 12. Someone can score a 20 and still have diminished capacity. At what point is it okay to let someone make bad decisions for themselves if they are competent?
So I think that goes back to our first case where a lady did have dementia, but she was able to make that specific decision. That was easy for her. You know, she might not be able to remember 3 words at 3 minutes, but if you would have several conversations with her, she would always come to the same answer based on her personality, her previously expressed wishes. So again, you have to say, can this person make this decision at this time? Now, if she's got a UTI and is delirious and in the ICU, she can't make it at this time, but maybe a month from now when she recovers, she would be able to be involved in that conversation.
That's really
so Lauren, let's go to the next slide. Oh, okay, go ahead, Kerry.
Oh, I just wanted to say I agree. It's very time sensitive in terms of when those decisions are made and whether it's affected by infection or medication. We don't know particularly at the time. How are we doing on time, by the way, Lauren? We should move to the next slide.
Yeah, we have one more round and then we'll finish up with some questions. So round 3.
Ding, ding,
Okay.
ding, 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 ding.
All right, this is Carl. Carl has moderate dementia. He is unable to make a decision. No advance directive, no family or surrogate. And Carl is when I pick up the phone and I call Kerry. So next slide.
So the next slide relates to guardianship, and we've talked about it a little bit. Let's, Laura, next slide, please. So, you know, the question is, can people make their decisions autonomous, or do they require protection? And in our country, it's both a good thing and a bad thing. Competent adults have the ability to make bad decisions. And we see this quite frequently in the context of financial exploitation. There's clearly a trend in which older adults today are being exploited on the internet. And usually it's the elderly men that are exploited by young women face to face. But on the internet, we're seeing a lot of older women exploited by younger men on the internet who live at the other side of the globe and have persuaded an older woman that she is the love of his life, and all she has to do is send him money to prove it. And of course, that's not the way it's phrased, but that is the way it goes. I was involved in a case in which an older woman was a upstanding, significant member of the community, and she continued to give money to this gentleman who she never met, never saw. She kept sending him money for plane tickets, and oh, by the way, he never showed up. So fundamentally, at the end of the day, as I mentioned earlier, a guardianship is a determination as to whether somebody can make their own decisions. Let's go to the next slide and talk about it in some detail. Consider whether a 30-year-old non-disabled person would have the right to make the same decision without interference by those who would seek to protect the person from their own folly. So I think it's safe to say that older adults suffer from probably what we call ageism. But in most instances, the outside observation, the medical community, the adult protective services, and the legal community are using their best efforts to protect someone. But we've already talked about earlier in our presentation, an older adult who is capable of making a bad decision. You know, Betty knew that perhaps she could live if she had a mammogram or if she had but decided she was had lived a wonderful life and didn't want to undergo any more surgical intervention. Next slide, please. So why guardianship? There's no one to make decisions. Dr. Braund has talked about the plethora and increased volume of unbefriended elders coming to the ER or even coming to her office. Elder abuse, financial, elder, physical, emotional abandonment. We're just seeing a massive pandemic, for lack of a better term, I would call it an epidemic, of older men being exploited by younger women. I call it love at first sight of their wallet. And the younger woman engages in a physical relationship with an older man. And basically, I call it also sex for signatures cases. I've stepped up in the courtroom and said, Judge, this is a sex for signatures case. The woman has traded sexual favors in order to get a signature on a deed, in order to get a signature on a trust amendment, in order to create a new will for this older adult who is likely to be cognitively impaired. He may be depressed. He just recently lost his wife. He may be demented. We don't know. But in a guardianship case, we go in. If he's cognitively impaired to the point of requiring a guardian, we freeze his assets so those assets can be available for the older adult's future health care. Next slide. So how do we determine the need for a guardianship? We need to establish certain disabilities, but that alone is not sufficient to support the determination of incompetency. The evidence must show the person's inability of managing one's person, that's their medical care, and their estate, the management of their money. This causes to bring to mind, I was appointed guardian ad litem. The court appoints a guardian ad litem to go out and interview the older adult. Today it's done virtually at the nursing home, at the hospital, at their own home, and determine their mental capacity and advise them of what I call their probate Miranda rights. That guardian ad litem is a lawyer, and that guardian ad litem is obligated. You see, in criminal cases, the Miranda rights are, you have the right to remain silent, you have the right to a lawyer. In probate, those rights are, you have the right to come to court, you have the right to another medical exam to determine your mental capacity. Very, very important. You have the right, if you wish, to a jury trial. But this type of scenario here calls to mind a case in which when I was appointed by the court as guardian ad litem, I went out and saw a young lady, relatively young, who only had the ability to communicate by blinks of the eye, okay? And one blink was yes, and two blinks was no. And at the end of the day, the court determined, and I recommended, that she have a guardian because blinks of the eye was not an effective mechanism to communicate her needs in the management of either her medical care or her finances. Next slide, please. So, although a person may be disabled in the statutory sense, a guardian's appropriate only if they're not capable of making or communicating, which I just talked about, responsible decisions. Again, people can make bad decisions. I was involved in a case in which a veteran came in and told the judge, I'm happy to die with a gangrenous leg. The hospital came in and said it needed to be removed. And the veteran said, Judge, I understand I will have an ugly, horrible end of my life, but that's what I want. Next slide, please. So this is kind of the underlying reasons that we file for guardianship, pretty broad, but it is statutory, straight from the Probate Act. Mental deterioration, physical incapacity. Mental deterioration, of course, could be Alzheimer's, it could be vascular disease, it could be Parkinson's, Alzheimer's. Physical incapacity, we talked about blinks of the eye as a result of a stroke. She couldn't move. Mental illness, bipolar disease sometimes, very, very difficult in a guardianship case. The last bullet point, gambling, idleness, debauchery. I'm still not sure I know what that is, but certainly excessive use of drugs and intoxicants, or a spendthrift. They just spend all their money giving it away to people now on the internet, or in the old days, people that solicited and still solicit for charitable contributions. Next slide, please. So Dr. Braund is critically important to a determination of the necessity of guardianship. And the doctor must complete, and the doctor notes that doctors hate filling out these forms. In Cook County, and it's basically been adapted by all the surrounding counties, we have a court-provided medical form, and that court-provided medical form is what's called a CCP, Cook County Probate Form 211. That form is what's the basis for a determination as to whether the court assesses a need for a guardianship. So it's a medical and legal undertaking, and it would shock everybody listening that medical and legal, and particularly in linguistics, they don't get along real well. We talked early on, Dr. Braund pointed out accurately the difference between capacity and decisional ability, or incompetency and decisional capacity. So this form requires that the doctor diagnose the patient, lay out the prognosis, the appropriate housing scenario, and a determination. The statutory magic language is Kerry Peck is totally incapable of making personal and/or financial decisions, or Dr. Braund is partially incapable of making personal and financial decisions. So guardians come in a couple different forms. A plenary guardian is a full guardian, and a partial guardian is what it says, only partially. Doctor?
And Kerry and I were talking earlier in the week, and he was just saying sometimes it's like pulling teeth to get the physicians to fill out these CCP 211s, and it's written in very legalese, and they're only my second least favorite, right after the FMLA forms, which are really incomprehensible. But it's really important. The nice thing is that if there has been a neuropsychologist, a social worker, another professional or provider who can add to that, the physician has to sign it, but Kerry, the court will look at those other professional notes and opinions, correct?
Absolutely. The court will take into account all of the people that write notes on that medical report. And notably, the law does not allow a PhD to sign this form. It must be an MD, a medical doctor. There is a movement afoot to change that, I think, from certain members of the medical community. But currently, it must be a certified medical doctor. And you need to provide your medical license number on this form. And that medical license number is actually read into what we call the record. So the court reporter is taking down Dr. Braund's medical license number, 123, signed this report and wrote the following about Susan Scatchell, something of that nature.
All right, next slide.
So I think that, the doctors talked about a comprehensive multidisciplinary evaluation. I think that's very important if it can be done. Regrettably, time is of the essence in many of these cases, certainly in financial exploitation cases, certainly in unbefriended elder cases, the hoarding cases. I was engaged by the city of Chicago some years back to rewrite the state of Illinois Elder Abuse and Neglect Act. And that Elder Abuse and Neglect Act at the time focused on a couple very significant changes, including adding hoarding to the context of self-neglect. The city was very concerned at that point in time of what Mayor Daley then called cat houses, which were homes that had just teeming with cats and animals, and the hoarding was just absolutely stunningly outrageous. I was sent by the court out to a cat house one time, a beautiful, beautiful mansion. I was met by a City of Chicago Department of Aging representative. We walked in when the lady finally opened the door. There were no lights on. There were newspapers stacked from floor to ceiling as high as you could see. And we felt like we were rats in a maze, because once we moved away from the front door, which was open, there was no light and we couldn't see anything. We were very, very taken aback. Up above, we started to hear and regrettably smell and be overpowered by the smell of, at that point, probably 100 or more cats that were up above, some of them dead, some of them alive, and all of them excreting in the home. So that's a horrible scenario of self-neglect. There certainly are varying degrees of self-neglect, but Dr. Braund gets those cases in the ER, and ultimately they may go to Adult Protective Services, and they may go to the courthouse in the context of a guardianship. That's kind of the fast trace of those types of cases. Next slide, please.
Kerry and Dr. Braund, we have a question about a workman's comp patient who needed rehab after a hospitalization. And the rehab facility would not accept the patient until she had a mental status test from the state. And she had to stay an extra 3 days in the hospital waiting for the test. She had no cognitive issues. It was a huge expense and a delay. So can you elaborate a little bit on that? Or is it the determination of need assessment? Is that different from the a cognitive issue test?
I've never heard of anything like that. Although when I hear workman's comp, then the financing of it gets to be an issue. And I wonder if they were just throwing up barriers. I don't know. I've never heard anything like that.
I'm not familiar with workman's comp. I don't do that kind of work, so I can't really comment.
Let's skip ahead to the next slide. I want to leave a couple minutes for questions here. It's so great to have the interaction from the audience. So next slide. So here are the take-home points today. all of us, some of us are seniors, but we need to plan for unexpected or inevitable decline. And whether it's cognitive, physical, mental, financial, generally, most of us are going to have some changes as we go from 50 to 60 to 70, 80 to 90. And then really we need to think about who best to make these medical and financial decisions. Complete the durable power of attorney for healthcare. That's the cornerstone. If you don't do anything else, do that. We're not going to talk about the PULSE, the physician order for life-sustaining treatment. That's the written down DNR order. If you don't do it, the states or the courts will, and I think Kerry would agree that it's probably not the best way to get things done.
I would agree. You need to plan in advance. Take advantage of your opportunity to express your wishes, your desire with your loved ones in advance. Otherwise, as the doctor said, the states or the courts will be forced to take over. And frankly, your end-of-life decisions do not belong in a courtroom. They do not belong anywhere other than between your healthcare providers and your family. So make those decisions while you have the capacity to make those decisions when you're not pressured for time and can think clearly. Lauren,
Yeah.
we have some questions. Winner is.
Ta-da!
Yeah.
All right, this is a good slide for questions. Lauren, what you got for us?
There actually really isn't anything right now. To continue with that workers' comp question and comment, they're saying that the fact that it was a workers' comp case wasn't the issue. It was the rehab facility that was the issue. I don't know if that makes any difference.
Yeah, I work in long-term care in post-acute, and we always say we're the catcher. We take what the hospital pitches out to us. So we take what we get, and a lot of times cognitive exam is not really well suited for the hospital. The patient is sleep deprived and medications are changing, and there may be opioids or sedatives on board. And so we generally really recommend that the patient have their cognitive test when they're more medically stable, and that might take weeks. So that's something that I would put on my list of things to do, but it should never hold going on.
Okay, we have a question. I am the primary caregiver to my 91-year-old mother who has Alzheimer's dementia. I'm her agent on her power of attorney. What do I need to do to prepare for any situation where something happens to me and I pass away while my mom is still alive?
Well, it's a great question. I think that there is a provision if you indicated that your mom already has dementia, so she can't make any further decisions. There are provisions for a standby guardianship or a standby guardian to be appointed for your mother. At this point, that's about all you can do, really, is try and name someone else to take over for you when you're not able to be around. At that point, I also think you should start interviewing either care agencies or geriatric care management agencies, a combination of both, and start laying out a game plan in advance with perhaps Home Instead, who's sponsoring our events today, or a geriatric care management company to make arrangements in advance. Again, the key here is in advance, and the best of your ability. There are some limited options there, but there are some options.
And then there's another one, just to clarify, you can download a power of attorney form online and all you need is a witness.
Correct.
Right.
And the one that we use at the hospital is 3 pages. It's like a cover sheet, and then it's like I put my name in, you know, blah, 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 appoint these people, blah, blah, witness and sign. It's easy peasy. The one I got from my attorney was 17 pages long, and I don't understand any of it, but somewhere in there is whatever. So, Kerry, I always love how you guys make a mountain out of a molehill.
Yeah, that's again where linguistics don't necessarily match medical legal.
Right.
There is a statutory form. I think some of them do require notarization. So take a look at it, but there's a statutory form. You can get it from generally the Illinois Department of Public Health or the Illinois Department of Aging. And there are a variety of resources out there. Senior centers typically have those forms and are available for everybody. Any final questions, ladies and gentlemen? Susan, anything that you'd like to cover?
I think
Do you like my comment about the doctor witness protection program? Since geriatricians are rare as hen's teeth, we keep a low profile. We run under the radar. I don't need 35 people calling me after this presentation, like, come see my horrible, nasty, hoardy client. Ah!
All right. Well, that was exciting and entertaining. Thank you to both athletes for an outstanding performance. A copy of their presentation and link to the recording will be made available on the chicagomemory.org website a few days after the event. Also on the website is a link to complete an online evaluation. We welcome feedback from all of the spectators, especially those that need CEUs. Next, I'd like to invite Linda Smith to introduce our next event and athlete.
Hi.
Hi, Linda.
Hi, thank you, Lauren. A reminder that this next session will also be recorded. Our next event, and the event is weightlifting,